and we would be talking about expropriation in detail, and particularly when we talk about expropriation, it would be both judicial and regulatory. But before that, just taking a step back and looking at things in a more basic perspective. All of this obviously starts with the treaties which the one state or the another state, or one country or the another country enters into, mainly to promote and facilitate the investments and the environment between those two countries, and to ensure that there is dual benefit given to both the countries in terms of doing that business. We colloquially call it BITs, or Comprehensive Economic Cooperation Agreements, or BPAs, and things like that. What does it generally entail? Obviously, first thing which we look at in BITs is where it is applicable. So whether it is applicable before you make an investment, whether it is applicable at the time when you make the investment, or whether it is applicable after you make your investment, and where does the protection come from. So that's one part of it. And obviously expropriation would fall under to the third category, as to once you have made this investment, how does the expropriation articles or the clauses under the BITs would help you in protecting your investment in a particular country. The other portions of BITs would obviously talk about the fair and equitable treatment clauses, which an investor would expect when they are investing in a different country. MFN clauses, and of course the dispute settlement mechanisms and things like that. So as the topic suggests, expropriation, what does that fundamentally mean? It means, in a very simple language, any legislative or administrative action taken by the sovereign or the government agency or a government body, which particularly takes away the investors' rights. Rights can be in the nature of ownership. So you own an asset, and now today you don't have the right to own that asset. Second is to control. So you have a control over the asset, or you have a control over the business, or you have some kind of control over the benefits that you are going to take, and you lose those controls because of certain acts or omissions on the part of the legislation or the sovereign in which you have invested. It also means that it doesn't only restrict your rights to the ownership and control in a direct way. Even an indirect expropriation, to the extent that you lose your right to enjoy, or you lose your right to use, or you lose your right to avail the benefits of your investment or assets in a country, would also amount to expropriation. So that's the very simple and basic understanding on expropriation. And where does it flow from, right? At the end of the day, none of these principles come just because you have entered into a treaty, or just because there is certain contractual obligation between the states. To my mind, it flows from the very fundamental principles of legitimate expectations, and this is found again back into your fair and equitable treatment expectation when you enter into an investment, or when you enter into a business with any other country. So anyone who is doing this business, or anyone who gets into an investment, or anyone who legitimately expects that certain kind of treatment or a certain kind of environment is what they are going to enjoy when they enter into that country, so that they can own, they can control, they can enjoy the benefit, use their assets, and obviously ensure that whatever they expected is what they are getting from the investment they are making. Again, it's not a very simple definition of expectation to be very precise, because this is not a simple intentional expectation or a hope that you get when you enter into a country. As Anirudh briefly mentioned, it has to be a specific right. It has to be a right which is enforceable. Either it can come from a statute, it can come from a contract, it can come from the grant, the license, any other form which you, when you enter into a country. But it can't be a simple expectation to start with. It has to be some right which is getting altered because of either of the action or omission on part of the sovereign. Second, it has to specifically deprive of the benefit. Again, when we say deprive of the benefit has to be something which relates of something which you have already got in the past, and therefore you have an expectation that even going forward you are going to get this benefit. Or it can be in form of some assurance that this benefit is going to come to you over a period of time in the future. So two tests in a nutshell. One, it has to be a specific right and not just a hope in terms of expectations. And two, it has to alter that right which results into deprivation of this benefit. So a lot of time when we talk about expropriation and then we get into either judicial or regulatory, I think the interplay or the overplay between the fair and equitable treatment where you are given a right for non-denial of justice in case of judicial expropriation and legitimate expectations in terms of regulatory expectations become that much more important. And where does this legitimate expectations come from? Again, it goes back to the local administrative law provisions, because at the end of the day, that is what a citizen also, right, is allowed to expect when they are doing business. And therefore, that's what leads to a fair and equitable treatment for even a foreign party which comes to that country and is trying to do the business. So it actually flows to the very basis on which the administrative law or your constitutional rights in that sense of Article 14 and other flows from. That okay, this is what you legitimately expect, this is your right, this is what you expect when you do a business in a particular country, in a particular set of facts. And if there is some action or inaction or a legislation or any other act which specifically denies the right which you want to enjoy or the benefit you want to enjoy because of your investment decisions, is what ultimately leads to your claim under expropriation. So again, going into more specifics on expropriation, as we discussed, it flows from one, the administrative law to start with, then it goes to the legitimate expectation in particular, and then obviously when one understands what is your expropriation in that sense or the claim of expropriation, and again the four sets of tests which Anirudh specifically mentioned of public purpose, non-discriminatory, due process and compensation, has to also satisfy certain other principles when it comes to any claim of expropriation. So what does one have to go through or what it entails when you want to specifically claim expropriation? In my view, the first thing the tribunal or the person who is going to adjudicate your claim would have to get satisfied the degree of and the severity of the expropriation, right? Because it can't be one or two single act or something which is in a normal course which is required for, let's say, public purpose, or which is not arbitrary and things like that. So I think the degree or the severity of the act or omission which you are alleging needs to be specifically talked about, and the tribunal has to satisfy themselves as to whether there is enough severity here to ensure that somebody can really claim under expropriation. Second, one has to also see the purpose and the context as to where this comes from, why a certain act or why a certain omission. So again, that purpose and context has to flow in, because a simple act of not giving license or not renewing license or forming a law which is required in unchanged circumstances necessarily do not form a part of an expropriation claim. And the third test again goes back to your expectation issue, that is whether such an interference or such a measure taken by the sovereign is ultimately hitting to the very nature of the expectation you had. If it is not connected to the expectations when you invested, then again it would be very difficult to satisfy your claim so far as expropriation is concerned. So with those opening remarks, I would possibly give the mic back to Anirudh, and once we go through a little more in detail specifically on judicial and regulatory expropriation, we can come back on the general principles and talk about a few things.
When you look at the two clauses, the fair and equitable treatment clause and the expropriation clause, when you look at when you read in a legitimate expectation, you need to look at the conditions prevailing at the time of investment. So if an investor voluntarily goes and makes an investment in a country which is known to have a continually changing regulatory framework, it is perhaps arguable that tomorrow he cannot argue that a modification in the regulatory framework is not against his legitimate expectations. However, this will not be a protection against the expropriation clause. That would be an instance where the two would apply in sort of separate avenues. Now that we've seen the overlap between the fair and equitable treatment clause and the expropriation clause, let's move on more specifically into regulatory expropriation. Regulatory expropriation, as the name suggests, is a regulation enacted by the government. Very often you are faced with a situation where such a regulation is for furthering the interests of society, like for environmental concerns or health concerns. What about a scenario tomorrow if the government comes up with a regulation sort of setting a cap on the price of cancer drugs? Can tomorrow a foreign investor who invested in a lot of research in India on these cancer drugs claim that his rights have been expropriated? I would now give the mic to Prabhash and he'll take you into further details.
Thank you, Anirudh. It's not very often in India that you have practitioners, academicians and a High Court judge interact. So I should compliment National Law School Bangalore for providing this platform and creating this platform, which is quite unique. This sort of interaction, as I was discussing with Pramod also earlier, should happen more frequently. Academicians should meet practitioners and judges should meet academicians, because then that will help all of us to develop our own understanding. I will talk on regulatory expropriation, but before I do that, I would like to make a general comment trying to distinguish investment treaty arbitration from international commercial arbitration. This distinction, to the best of my knowledge, is not very well appreciated and understood in India. And this distinction is very, very fundamental. Investment treaty arbitration follows the adjudicative model of international commercial arbitration, but performs functions or jobs which are very, very different from international commercial arbitration. In investment treaty arbitration, although you have privately appointed arbitrators, but these arbitrators don't judge private law questions. They actually sit over judgment on sovereign regulatory conduct of the state. So this sort of puts investment treaty arbitration in a very, very different context. It is kind of a hybrid system which uses a private law adjudicative model to settle public law questions. A lot of scholars have tried to conceptualize investment treaty arbitration as part of what is often known as the global administrative law. That what the investment treaty arbitration tribunal does at the end of the day is not very different from what a constitutional law court or the administrative law court would do, which is to review the actions taken by the executive or the legislature. So this difference, I think, needs to be very well understood for us to understand the nuances of investment treaty arbitration. Now, on the question of regulatory expropriation, I thought I'll talk about indirect expropriation for the very simple reason that now the world in which we live, direct expropriations have become quite rare. States sort of do not go on mass nationalization that used to happen earlier, but states do adopt regulatory measures, and these regulatory measures may have an effect which is equivalent to that of direct expropriation. Now, it's easier to say that measures which have an effect equivalent to direct expropriation are also expropriation. It is very, very difficult to determine when that boundary is crossed and when regulation becomes expropriation. So far, there are essentially two ways to look at this particular question. The first is often known as the sole effects doctrine, where the argument is that whether there is expropriation or not entirely depends on how severe the effect is on the foreign investment. And the legal basis for this particular test is textual. In other words, if you look at majority of bilateral investment treaties, and that's another important and unique aspect of the system, that you don't have one common law to apply, is how severe the effect is on the foreign investor. But then this also doesn't answer a number of other questions. For example, which investment are we talking about? When a foreign company comes and invests in a country, it acquires a bundle of rights. There may be a small contract, there may be a larger contract. It is quite possible that sovereign conduct has repudiated one contract. Now, is it expropriation? Even if the large part of investment of this particular corporation is unaffected? And the BIT doesn't give you answers to this question. Scholars have come up with concepts of conceptual severance that you need to determine, in this bundle of rights, which are the bundles which, if expropriated, would amount to expropriation under the BIT. And it is a question on which the opinion is divided. Apart from the sole effect doctrine, which talks about substantial deprivation of the investment being the sole indicator to find out whether there is expropriation or not, some other tribunals have come up with an alternative test which is known as the purpose approach. Now, this purpose approach is very, very interesting, and it is important for us to understand what is the basis of this purpose approach. The purpose approach essentially is a response to the critique made by many people that bilateral investment treaties are resulting in a regulatory chill. Countries cannot adopt regulatory policies because the moment they adopt regulatory policies, these are challenged by investors as violation of bilateral investment treaties. There's something which sort of has specifically happened in the last decade or so, when you had Argentina as a very good example, which sort of faced a very severe economic crisis, passed a number of emergency legislations which had an adverse impact on many US investors and European investors, and they all challenged these emergency legislations as violation of bilateral investment treaties. Now, as a response to this critique that BITs actually do not result in regulatory chill, BITs do not curtail the ability of host governments to regulate, a new approach has been adopted to look at indirect expropriation, and this is known as the purpose approach. As per the purpose approach, you look not just at the effect of the measure on the foreign investment, but you also look at the purpose with which that measure was adopted. And if the measure was adopted to further a public objective, then it is not expropriation. Just to sort of give you a small little quote from an investment treaty arbitration tribunal, which is known as Saluka Tribunal, it said this: "It is now established in international law that states are not liable to pay compensation to a foreign investor when, in the normal exercise of their regulatory powers, they adopt in a non-discriminatory manner bona fide regulations that are aimed at the general welfare." Now, my own take on this is that this is too sweeping, because if you sort of say that states are not liable to pay compensation for regulatory powers they adopt to achieve bona fide regulations, then you actually are saying that the moment public purpose is to be served, no compensation needs to be paid. Now, if that's the case, then you're actually rewriting the entire concept of expropriation in international law, not just in international investment law, but also in international law. So the first critique of this is this particular provision is too differential to the interest of the states without taking into account the concern of foreign investors. There are some other tribunals which have adopted a more nuanced approach and the purpose approach, and this can also be known as the proportionality approach, which some tribunals talk about. And they say that what we need to see is whether there is the measure adopted is proportional to the end which it seeks to achieve. Now, again, a problem with this particular approach is that test of proportionality, as we all know, has evolved as a judicial technique to weigh and balance different conflicting rights and values at that particular point of time. But then it is also important to see who are the people who are doing this or who are undertaking this delicate balance. They are not the judges of a particular national legal system, but these are privately appointed arbitrators who are not embedded in the system. And therefore the question comes that are these privately appointed arbitrators have the institutional mandate and the competence to undertake such delicate balancing between the rights of the foreign investor and the regulatory objective the state wishes to pursue. In my view, they are perhaps not positioned to undertake that delicate balance, and therefore they should not get into something like a proportionality test which is too intrusive into the sovereign space of the host country. The third critique which I have of the purpose approach is this: all the tribunals which have evolved the purpose approach have not provided a very solid legal basis for this particular approach. In other words, their determination is more from a normative point of view. It almost appears as if they are responding to the critiques who say that BITs encroach onto the host state's sovereignty. Now, as a treaty interpreter, your job is not to respond to the critiques. As a treaty interpreter, your job is to interpret the treaty using the rules of treaty interpretation. And if we look at the language of the bilateral investment treaties where the purpose approach has evolved, the language of the treaty does not support the purpose approach at all, because the language of the treaty solely focuses on effect. And if the treaty focuses on effect, then what is the textual basis for you to bring in the purpose approach? We all know that the very concept of expropriation is that you can expropriate for public purpose provided you pay compensation, and this approach actually blurs that distinction and sort of muddles up the entire understanding on expropriation. Therefore, to sort of conclude on these preliminary thoughts, and we can have a discussion further, proportionality test or the purpose approach surely answers some questions, and these questions mainly are that BITs are too intrusive into the sovereign space of the host country. But then if the concern is to preserve the sovereignty of the country, then that needs to be preserved by reformulating the substantive law. In other words, a defect in the substantive law, in my view, cannot be overcome through judicial interpretation, especially if it happens to be in case of investment treaty arbitration. If there is indeed a problem, and I sort of accept to that problem of BITs encroaching onto the sovereign space of the host countries, then states have to be more careful in sort of entering in those kinds of BITs which preserve the regulatory power of the host state and do not sort of have provisions which give too much or which have very high investment protection features. Thank you.
Thank you very much for that. Point of critique, from a fundamental theoretical point of view, if you're going by the purpose approach, where you say that if there's a bona fide acquisition of, if there's a bona fide regulatory measure which is being which is non-discriminatory in nature, then no compensation is payable. You are in fact saying that where the public, for a public purpose, you acquire a private right, the private right is at naught. Should not the public purse be sponsoring the acquisition of this private right? That's the issue that I raised, which we can discuss at a later point of time when we take this forward. We now move on to judicial expropriation. As the name suggests, this is acquisition of a right by way of a judicial act. Take the typical case of the 2G case, where the 2G licenses have now been cancelled by a decision of the Supreme Court. What about the right of those who were in fact awarded the license, like Telenor? This would be a typical case of judicial expropriation. The fundamental issue that arises here is an issue of attribution. Can you attribute an act of the judiciary to an act to the government itself and hold them liable under the bilateral investment treaty. Aditya will be going into the issue later.
Thank you, Anurag, such distinguished luminaries. Now, what I'm going to do through the course of my presentation is talk to you about three basic things. The first is the question of attribution and whether judicial expropriation can be attributed to the state. Of expropriation by the judiciary, which is what we're discussing today. And more particularly on the idea of exhaustion of local remedies, which will come up often. And lastly, before I hand it over to Mr. Nair, who will discuss in great detail the case law on judicial expropriation, I'd like to give a peculiar case which has come up before the ICSID, which brings up a lot of important questions. And my dad once said that if you don't have the answers, make sure you ask the right questions. So hopefully I'm going to try to put forward at the very least the right questions before the panel. Now this whole question of attribution is simple. It's when can the acts of certain entities be attributed to a state? Now, most typically, the question of attribution becomes tricky in the area of, say, umbrella clauses where there's a private contract involved. But here, let's taper the discussion down to purely one on the judiciary. With respect to attribution of acts of the judiciary, we need to look at whether the ILC articles can be applied at all. Now, the ILC articles are essentially the document which determine whether attribution of certain acts should be made to the state or not. So Article 1 of the ILC articles provides that every internationally wrongful act entails international responsibility. Article 2 goes on to expand on what Article 1 says. It says that an internationally wrongful act of a state requires attributability of the conduct, which in this particular situation the judiciary is clear by virtue of Article 4(1), which clearly provides that the judiciary's acts can be attributed to the state. So that's not really a problematic area in terms of attribution. The second requirement, however, is something I'm going to spend a little more time on. That talks about how the act must constitute a violation of an international or a breach of an international obligation. Now this breach of an international obligation must be read, and it's my submission that it must be read in light of a correlated right of another state. So if you look at decisions by the PCIJ, especially in the phosphates in Morocco case, I beg your pardon, the act in question, the court said, must be contrary to the rights of another state. So the question then becomes, when does the act of the judiciary become contrary to the rights of another state? And when can this particular act of the judiciary be claimed to be a violation of an international obligation? Because without satisfying that basic requirement, the whole question of attributing the actual act of the judiciary cannot arise. So with that question in mind, I'm going to lead to the next part of my presentation, which deals with denial of justice. Now the idea of denial of justice is a peculiar one. Like I said right at the beginning, it's well settled that a judicial claim is indeed attributable to the state. Therefore, if there is a claim against the judiciary, it can be made under the investment treaty. That's clear. However, a denial of justice can be made either in the form of an expropriation claim or a claim under the FET, as Mr. Desai spoke about earlier as well. So the important question that must be kept in mind while discussing this idea of denial of justice, and more specifically expropriation by the judiciary, is what is the line that should be drawn in order to prevent the international tribunal into just becoming an appellate body for local courts? That's an important question that must be thrown out while discussing this idea of looking at expropriation by the judiciary. Secondly, what is the standard that must be established, especially for the judiciary, to establish this international wrong? That's a question that needs to be looked at more intensely. And finally, is the concept of denial of justice a systemic one? Now what I mean by this is that, is it denial of justice and is it expropriation when there is a failure of a judicial system to conform to an international standard? Or can single instances also bring about a claim of expropriation? Because let's accept the fact that since this is an internationally wrongful act, there is an international standard or an obligation that must be violated. So there are two situations now, not just one where it's one instance where it's allegedly expropriation, but the other where the whole system has seemed to have failed the international standard which is required. I'm going to tell you about why I think the systemic theory makes more sense. Now, one of the major problems or one of the major issues that comes up with respect to a denial of justice or an expropriation by judiciary claim is the exhaustion of local remedies. one of the interesting concepts that arises in investment treaty arbitration is this concept of fork in the road clause. Now, I'd like to just briefly talk about this one case of Pangton Chinky, where they talk about the tribunal itself talks about bringing about a claim before an investment tribunal where a claim is also available against the local courts. Now, briefly, the court just said that the tribunal explained that the finding of the local courts did not preclude the investor from bringing other claims based on the treaty, including one for denial of justice based on alleged mistreatment at the hands of the Albanian courts. So obviously there is a possibility, and there is no stringent requirement to exhaust all your local remedies before approaching an investment tribunal. Now, how will this problem of waiver or exhaustion of remedies be taken care of if the system has to fail as a whole? Firstly, there cannot be this idea of systemic failure without using other avenues available. Obviously, if the allegation is that there has been the systemic failure by the judiciary, then every arm or every avenue available to the party has to have been exhausted. Logically speaking too, this makes sense, because if this was not the case and if every avenue indeed was not exhausted by the party, then what would happen is that at every level there could be a claim for expropriation. There could be one at the lower court level. It doesn't have to be a final decision made by the highest court of the country. That's another problem which is obviously taken care of if the systemic theory is adopted. The next question is, and I think this is one of the more interesting things that the systemic theory does, is that it converts the question of exhaustion of remedies from one of a procedural one to that of a substantive requirement. Now, because there is now, in order to violate that international standard which you said is the systemic theory, which the systemic theory puts in place, in order to violate that standard, there has to be a compulsory exhaustion of local remedies. It not only makes it it doesn't anymore become a procedural requirement where parties agree that the local remedies have to be exhausted. Instead, in order to fulfill that high standard of violation of an international obligation, the parties must prove as a substantive requirement that the local remedies have been exhausted. But there are exceptions to this condition, and these are some of the interesting questions I would like to throw to the panel. Is that what if the proceedings are just stuck, or say that they take too long, possibly intentionally they have been made to take too long? Would such a requirement still hold in international law? Secondly, what if there are unreasonable restrictive costs which have been imposed intentionally? In that situation, would a similar standard still hold? Finally, ladies and gentlemen, I think this is going to be the most important part of my presentation, is which point will expropriation by the judiciary be held to be expropriation? Now, if I can clarify that a little, what I mean is, when is it a claim of denial of justice or expropriation? This is an important question to ask, because an expropriation claim in general is not a single act. Often there are a number of acts which take place before the particular action or before the particular transaction has gone to the judiciary. So there are a number of other organs like the executive or the legislature which has been involved at some stage. Now, where would you say that the judiciary is to be held responsible? Is it to be held responsible in every situation where it's just the final point at which the expropriation claim is being made? Or is it supposed to be held responsible where it's a substantive systemic failure purely by the judiciary? That's an important question that must be answered. Now, if I could just talk about what the consequence is. If the consequence is where we give such a wide definition to expropriation by the judiciary, where at every stage, right from the executive or the legislature stage, right up to the stage where the matter reaches the judiciary, if we hold the judiciary responsible for such acts of expropriation, it makes the definition extremely wide and essentially takes away the whole concept of denial of justice, which is an established norm in investment arbitration. Finally, there are two scenarios which Christopher Greenwood talks about, and this is essentially what sums up the situation. One is where there is directly attributable expropriation by the judiciary, where it's obvious that there has been systemic failure by the judiciary. The second is just a situation where, say, due process has not been followed. It's an ancillary step to what the expropriation claim is, but isn't the substance of the claim itself. Those two situations, I think, are the two marks between which investment arbitration needs to operate. It needs to ensure that it doesn't make the definition of expropriation so wide so as to hold every act of the judiciary to be expropriation, even though substantially speaking, a majority or the substantive aspect of the expropriation was done by, say, the executive or the legislature. Now that would be my submission with respect to denial of justice. Now finally, before I pass it over to Mr. Nair, I'd like to discuss this interesting case which was actually between Kyrgyzstan and Turkey. Now what I'm going to do is tell you the facts, the rationale, and like I said, some of the interesting questions that the case throws up in light of the 2G case especially. Now in 2005, the Kyrgyz courts invalidated certain agreements by which a Turkish investor had acquired interest in the company operating Pinara, which was a 4-star hotel in the center of the capital. The arbitral tribunal held that this decision had deprived system, the Turkish investor, of its investment and hence constituted an act of expropriation. It also said that since no compensation was paid, Kyrgyzstan had thus violated its obligations under the BIT. Specifically, while talking about expropriation through court decisions, the tribunal said that the tribunal's reasoning was rather straightforward. It said first that the decisions resulted in system being deprived of its assets. Therefore, it is some form of expropriation. Secondly, it says that since the actions of the court are, like I said, clearly attributable by the ILC articles, there is no doubt that this amounts to a deprivation by a court decision which leads to expropriation. Now, this was the rationale which is adopted. However, some of the important questions which are thrown up, is that was it, since the hotel agreement itself was held to be void, had it really owned an investment? Now, this is interesting in light of the fact that previous tribunals have held that where the particular investment is acquired under a void transaction, there is no claim which can be made under the BIT. Now, the cases like El Salvador, NLSIAM versus El Salvador, which back this claim up. This is important in light of the 2G case as well. Is that whether, say, at the base of it or at its very essence, if the agreement itself is said to be void, then could it be held to be an investment at all? Now, with this peculiar case, I'd like to throw the floor back to Anirudh and hope the panel has something to say on it.
Thank you. All right, over to Pramod now. Pramod now, take this one.
The good thing about being one of the latest speakers in a panel is that you have the benefit of these speakers before you completing much of what you have to say. So let me try and keep what I have to say to the minimum. What I'd like to focus on is the larger theme of state responsibility under international law for judicial actions. 2 days ago, UNCTAD, which is the United Nations Conference on Trade and Development, came out with its report on its analysis of investment treaty developments in 2012. And some of the findings of that study are quite relevant to today's topic. The first point that the UNCTAD study made was that 2012 saw the highest number of investment treaty arbitration claims ever made. The first investment treaty was between Pakistan and Germany, and it was concluded in 1958. But from 1958 till around 1990, there were probably just 1 or 2 investment treaty arbitration claims. But from 1990 to 2013, there's been a virtual explosion of investment treaty arbitration claims, and I think there are probably more than 400 claims that have been made, many of which are still pending. So the fact that there were 65 cases that were actually initiated in 2012 refutes some of the suggestions made in certain quarters that EIT arbitration is a bit of a novelty. And once the novelty factor wears out, it's probably not something that's going to be hugely relevant. The fact is that investment treaty arbitration is not going to go away in a hurry. There have been suggestions from some quarters that the investment treaty arbitration system is in need of urgent reform. Some of the countries like Ecuador and Venezuela have sought to vote with their feet and exit the system altogether, but the fact is, for the vast majority of states, they would like to be seen as investment-friendly jurisdictions, and one part of the mix to make yourself or to promote yourself as an investment-friendly destination is to have a fairly wide range of investment treaties. But
Another interesting statistic which the UNCTAD report came out with is in terms of the states against which these claims have been made. The largest number of claims were made against Venezuela. No surprise there, because it's probably been the respondent in the greatest number of investment treaty arbitration, probably second only to Argentina. But the next country on that list, it might surprise you to note, is actually India. So there were 9 claims against Venezuela, but there were 7 claims against India. And that's quite a staggering statistic, because the first investment treaty arbitration claim that was made against India was in the context of the troubled Dabhol power project. But then the next one, and the first one to actually lead to a decision, was the White Industries Award, which we'll probably discuss in some detail. But so there was one successful award, but something radical seems to have happened, because in 1 year alone, there were 7 cases made against the Indian government, and there are some which are probably just going to be crystallized into investment treaty claims. So it's probably worth seeing why that's the case. And one factor which seems to be quite common to these 7 claims is that there is an element of judicial intervention. All these 7 claims, in one form or the other, involve or entail the actions of the state courts. So in the Indian context, the experience seems to be peculiar in that the acts and omissions of the Indian judiciary is really leading to claims being made against India at the international level. So the relevance of this topic is very, very contemporary indeed. Anirudh mentioned the fact that claims were made in the context of the cancellation of the 2G telecom licenses by the Supreme Court in February last year. From an investor's point of view, for example, if you had Telenor, which came in and invested into a joint venture in India, or Axiata or System or any of the others who've actually made claims against the government, well, they came in and invested money in accordance with Indian law as it stood at the time. The policy of the Indian government in the telecom sector at that time was first come, first served. These companies invested in JVs which were granted licenses on that basis. And there's been no suggestion, much less a conclusion from any quarter, that any of these companies have been guilty of wrongdoing. But the effect is, although they were granted licenses or telecom licenses which had a validity period of 20 years or so, they were actually expropriated around 3 or 4 years into the term of those licenses. No compensation has yet been paid for this expropriation. And it's really when some of these investors have been pushed to the wall that they've actually resorted to investment treaty arbitration, which many say is the nuclear button. It's a measure of last resort. When you have really no other recourse, you have recourse to investment treaty arbitration. And I think in the context of the 2G telecom licenses, that's probably what happened, because you really don't have an appellate court sitting over the judgment of the Supreme Court. Well, of course, they've tried their chances in getting the judgment reviewed. There have been curative petitions that have been filed, but all those have been dismissed, and therefore the only recourse available to these foreign investors to protect their investments, or at least to get compensation for their expropriated investments, was to commence investment treaty arbitrations. So it's probably fair to say that the 2G telecom license saga is the one which has really spawned these 7 disputes that have been made against the Indian state. In terms of creating probably categories of claims that can be made against a state for actions of its judiciary, I think at least as per published arbitral decisions, they fall into one of 3 categories. The first category is when there's an expropriation of an investment, and the cases that I have in mind are cases like Saipem, where tribunals have held that an investment, or rather an arbitral award, is an investment, and if state courts refuse to enforce arbitration awards, there is an expropriation of an investment. So the first is the expropriation kind of case. The second is a denial of justice kind of case, and there's been a good explanation of what denial of justice is, so I'm not going to rehearse that again. But the fact is, denial of justice claims are not very common. They're not commonly brought in investment treaty arbitrations, and even if they are brought, they have rarely succeeded, simply because the threshold of proving a denial of justice by the state courts is a very high threshold indeed, and most people who try to make the argument have failed in substantiating it. The third, and this is the white industries kind of scenario, is where there is a failure on the part of the state courts to afford effective means to foreign investors to assert their or to enforce their contractual rights. And that's a kind of scenario which is probably going to be used even more going forward. Aditya has already touched upon the overall international law legislative framework, and the custom international law is very clear, which to the effect that if there is a default on the part of any state organ, then that's good enough to hold the state liable under international law. Earlier there was a view that a state really cannot be held liable under international law for the acts of its judiciary, and the argument was that under most constitutions there is a crystallized principle of separation of powers, and since governments cannot influence judicial decisions, you cannot hold governments liable for the acts of its judiciary. But the counter argument to that is it's not really a question of holding a government responsible for the acts of its judiciary, it's holding states liable for the acts of one of its organs. And just the way that the legislature and the executive are branches of the government, the judiciary is also a co-equal branch of the government, and to the extent that there is actions or omissions on the part of the judiciary which lead to violations of international law, there can be no reason, either in terms of logic or principle, to say that the state must be immune for the consequences of acts of its judiciary. Article 4 of the ILC draft articles of state responsibility, which I again referred to, is probably reflective of customary international law on this point, and it's quite clear to the effect that the conduct of any state organ shall be considered an act of that state under international law, irrespective of whether the organ exercises legislative, executive, or judicial functions. So it doesn't really matter which arm of the government violates international law. It can be the legislature, it could be the executive or the judiciary. A violation of international law by any of these organs is sufficient to engage international responsibility. There are a couple of decisions which I'd probably like to touch upon. One is the case of Saipem versus Bangladesh, and this is probably the first kind of expropriation case. What happened in this case was in 2009, an exit tribunal held that the Bangladeshi courts had really interfered with an arbitral award to such an extent that it constituted an expropriation of that award. And that's probably the first case, and maybe the only case which is really held that an arbitral award is an investment. Well, of course, the logic of the tribunal was that the rights essentially were crystallized in the arbitration award, and therefore, if contractual rights could be investments, then the award which crystallized all those contractual rights also had the characteristic of an investment, to the extent that a court did not enforce an arbitration award in favor of a foreign investor that was sufficient to constitute expropriation. Okay. Well, here there is probably an argument about whether or not Bangladesh had complied with its obligations under the New York Convention to enforce foreign arbitral awards. The reasoning of the tribunal was, at one level, there was compliance by the Bangladeshi courts, because what it did was it seems to have been an unlawful interference with the arbitral award, and that engaged international responsibility. Bear in mind that there is absolutely nothing in the New York Convention which creates jurisdiction in an international tribunal to sit in judgment over the decision of a national court to not enforce an arbitration award. So there is really, in that sense, no violation of the principles of the New York Convention. But a rather curious argument made, but this is probably the first international decision which has held a state liable for failing to uphold a supposed spirit of a treaty. The second basis of the tribunal's reasoning was that non-enforcement of the arbitration award was contrary to Bangladesh's obligations, because it did constitute what it termed as an abuse of rights. Now, the principle of abuse of rights is a fairly controversial doctrine under international law, and essentially the doctrine is that you cannot do something which is which you're permitted to do, but the effect of which is to really defeat one party's legitimate expectations. And what the arbitral tribunal did is that it said that there was, of course, the right that the Bangladeshi courts had to review whether or not to enforce an arbitration award, but exercising that right in such a manner so as to really deny the investor the benefit of an arbitration award amounts to an abuse of rights. And it said that the principle of abuse of rights is the principle of international law, and on that basis, Bangladesh had acted contrary to international law. There was just one problem with that decision, and the problem with the decision is there's really no source of law which supports the proposition that an abuse of rights is contrary to international law. In fact, the latest version of Brownlee on international law contains the statement that while the principle of abuse of rights is a useful agent in the progressive development of the law, as a general principle, it does not exist in positive law. So there was really a refutation of the theory that there is actually a binding principle which prevents abuse of rights in international law. There was no citation of state practice, there was no citation of opinio juris, there was no analysis of how the principle of abuse of rights had actually crystallized into a binding principle of international law. SIPEM was cited quite frequently in the decision of the arbitral tribunal in the case of White Industries versus India. This decision is probably something which many of you are familiar with, so pardon me if I delve into the facts a bit to set out the context. What happened in this case was White Industries obtained an ICC award in its favor in 2002 against Coal India in relation to a dispute over the supply of equipment and development of a coal mine. In 2002, Coal India applied to the Calcutta High Court to have the ICC award set aside. And the basis of this challenge proceeding was a decision of the Indian Supreme Court in a case called Bharti International versus bulk trading, which will be discussed on this panel. And in turn, what White Industries did was it applied to the Delhi High Court to enforce the award. The enforcement proceedings were actually stayed until a decision was made on the set-aside proceeding. And the reason why all this confusion took place was in Bharti International, the Indian Supreme Court had held that the Indian courts have the power to entertain a challenge to a foreign arbitration award, notwithstanding the fact that the seat of the arbitration was not in India. On the basis of that decision, the set-aside proceedings could actually be entertained by the Calcutta High Court. The decision of the Calcutta High Court to stay the enforcement application was, or the decision of the Delhi High Court to stay the enforcement application until a final decision was made on the set-aside proceedings was challenged by White Industries before the Supreme Court in 2005. But for a period of around 4.5 years, nothing happened in the Supreme Court. And the reason why nothing happened in the Supreme Court was there were a number of cases which questioned the correctness of the Supreme Court's judgment in Bharti International, and the Supreme Court had constituted a constitution bench comprising 5 judges of the court to re-examine the issue afresh. All that took time, and anyone acquainted with Supreme Court litigation will understand that 4.5 years in the Indian context is by no means a fairly exorbitant time period for the Supreme Court to make a decision. But of course, the patient levels of a foreign investor is different. Frustrated with the delays in the Indian judicial system, what White Industries did was it approached an investment treaty tribunal constituted under the Australia-India Bilateral Investment Treaty. And the argument of the investor there was twofold. One was there was a denial of justice by virtue of the Indian courts taking so long to decide the enforcement application. And at the second level, through the MFN clause, what White Industries did was it incorporated a fairly beneficial provision contained in India-Kuwait Bilateral Investment Treaty. And that treaty contained an obligation on the Indian courts to provide effective means of asserting claims and enforcing rights with respect to investments in accordance with Indian law. And although the tribunal said that there is no question of a denial of justice having happened in this case, there was certainly a violation of this obligation to provide effective means of asserting claims and enforcing rights. And it said that a delay of around 4.5 years in enforcing an arbitration award meant that there was really no ways for a foreign investor to effectively assert its claims and enforce its rights under the Indian scheme. It's a bit of a surprising decision, and I think if you look at the award itself is confusing in parts, probably reflecting the fact that it was not an easy decision for the tribunal to make. On one hand, the tribunal said that it acknowledged the fact that India is a developing country with a population of over 1.2 billion people with a seriously overstretched judiciary. So it referred to the fact that there were probably 40 million cases pending before the Indian courts. Delays are fairly endemic in the Indian system. There's no suggestion that there was that white industries were singled out for discriminatory treatment. Through the MFN clause, what white industries did was it incorporated a fairly beneficial provision contained in the India-Kuwait bilateral investment treaty. And that treaty contained an obligation on the Indian courts to provide effective means of asserting claims and enforcing rights with respect to investments in accordance with Indian law. And although the tribunal said that there is no question of a denial of justice having happened in this case, there was certainly a violation of this obligation to provide effective means of asserting claims and enforcing rights. And it said that a delay of around 4.5 years in enforcing an arbitration award meant that there was really no ways for a foreign investor to effectively assert its claims and enforce its rights under the Indian scheme. It's a bit of a surprising decision, and I think if you look at the award itself is confusing in parts, probably reflecting the fact that it was not an easy decision for the tribunal to make. On one hand, the tribunal said that it acknowledged the fact that India is a developing country with a population of over 1.2 billion people with a seriously overstretched judiciary. So it referred to the fact that there were probably 40 million cases pending before the Indian courts. Delays are fairly endemic in the Indian system. There's no suggestion that there was that white industries were singled out for discriminatory treatment. But nevertheless, what the tribunal went on to hold was there was a global objective standard for this principle. Therefore, the logic of the judgment or the decision of the arbitral tribunal was if an arbitral award could be enforced in, say, a country like Switzerland within a period of 6 months, then since it's an objective standard, India would probably be held liable if it failed to match up to something like that standard, which seems to be a serious issue because what investment treaties are not supposed to do is to level the investment climate. When investors come into the state, they do come in acknowledging the conditions in the host state, and there are a number of judgments or there are a number of decisions of investment tribunals which say that investors must take conditions in host states as they find them, and investments or investment treaties are not insurance policies against legitimate business risks. When people come to India, they do recognize that delays are fairly commonplace in the Indian judicial system, and therefore the mere fact that a foreign investor encounters such delays does not necessarily mean that there is an attempt on the part of the Indian judiciary to deny justice or to deny access to effective means of asserting claims. Nevertheless, that's the decision, and the good thing about investment treaty arbitrations is that success begets success, which is pretty common in most other facets of life as well. So the fact that one investor has succeeded in essentially getting an award against the Republic of India has probably emboldened others, which explains the fact that there are now 7 claims. There are probably more, and there are probably 2 which are currently being drafted as we speak to be brought against India quite imminently in the context of a slightly different dispute. And that's the Davis-Amtrix dispute, which has also been reported in the press. And what happened in that case, again, is fairly exceptional. There was a contract between Amtrix, which is a department of the commercial wing of ISRO, which is the Indian Space Research Organization, and this company called Davis. They had a joint venture to explore commercial options of operating satellites. What happened in the aftermath of the 2G scam is that the government got cold feet and they tried to back out of this joint venture. Davis commenced an ICC arbitration, essentially seeking specific performance of the agreement, if not asking for damages. On the eve of the hearing of the ICC tribunal, which was constituted, the Supreme Court decided to intervene. There is no specific provision under the Arbitration Act of 1996 which allows an Indian court to enjoin an arbitration proceeding. So there's really no power under the Indian Act to grant an anti-arbitration injunction. But what the court did, and the way the matter reached the court was, Amtrix had filed a Section 11 application before the court by saying that the court must constitute the arbitral tribunal for the parties, despite the fact that there was an ICC tribunal already in place. The court, in exercise of its, well, there was really no specific powers under Section 11, but the court, under Section 11, said that it had the power to actually injunct foreign arbitration from proceeding. And the net result was that for a period of a year and a half, that ICC arbitration has not moved an inch. So frustrated with that issue, what the investors in Davis have done is that they've actually commenced investment treaty arbitrations against the government of India. So the reason why I touched upon that is that in the Indian context, what seems to have happened, especially over the last year and a half, is that it's very often judicial conduct which is at the heart of investment treaty arbitration claims made against India. It's the good thing about some of these claims is that it provides a fantastic opportunity for the government to intervene and to remedy some of these issues and problems which are endemic in the Indian judicial system. Unfortunately, the reaction of the government doesn't seem to have inspired much confidence. What it did, quite rightly after the White Industries decision, was to honor the award and pay the US $5 million award that had been granted to White Industries. But it did not use that as an opportunity to reform the system. The heart of that dispute was the fact that enforcement of an arbitration award in the Indian context takes time. It takes years on end. And what could have really remedied the situation and ensure that the White Industries kind of situation does not recur is to introduce arbitration reform and ensure that the Indian courts dispose enforcement applications within a time-bound period. And there couldn't have been a better opportunity for the Indian Parliament to intervene and effect such a legislative change, but that didn't happen. And on a concluding note, and on a slightly pessimistic note, what I would say is that if the situation remains the way it is now, White Industries may have been the first instance where India has been held guilty of violating its international obligations for failure to enforce an arbitration award within a reasonable time frame, but it very well may not be the last.
Thank you, Bruno. You mentioned the fact that an arbitral award could be treated to be an investment. Would that, you're all well aware that based on the Venture Global case, under certain circumstances, an Indian court can set aside a foreign award. This is prior to the BALCO regime, now that doesn't apply. But you all know that BALCO applies only prospectively to all arbitration agreements entered into post-BALCO. So if tomorrow an Indian court sets aside an arbitral award, would that amount to an act of judicial expropriation? In this regard, it's relevant to note the trend from Bhatia to BALCO and go into Venture Global at some length. And Justice Banerjee, who is the author of one of the leading decisions of the Calcutta High Court in this regard, will go into this aspect. And also, he will also be discussing the issue of judicial expropriation from a judge's point of view. Does this create a tribunal above the Supreme Court to review the decision of the Supreme Court? He will be going into the issue. Over to you, sir.
First, to begin with, generally when I am in a serious discussion in company of other judges, I tend to feel very young because I was appointed young and still continue to be one of the younger ones as a judge. But I believe by far I am the oldest in this room today. So I'll be slightly old-fashioned in some of my thoughts, but I'll bring you in as to where I come in the White Industries scene. There was a case which was pending before White Industries, which was for the enforcement of an arbitral award passed under the New York Convention in favor of a Canadian company, Canadian coal company, against Coal India Limited. And the facts were identical to White. And the matter came up before me as a single judge, and I delivered judgment some 6 months before the Kaiser BALCO judgment was delivered. And White Industries was cited before me as a binding precedent since White was by a division bench. And now I found judicial devices to hold that White was per incurium. It was not good law, and it was not good law by citing Supreme Court judgments, including one delivered after White, which was Fierce Day Lawson. So it was about 6 months before White was ultimately set aside by Supreme Court in the Constitution Bench judgment, that White was discredited in White's court of origin. Now, in Canadian Coal Company, there were a lot of problems that one had to grapple with. And as the opening paragraph, I don't know if any of you have read it, it's reported in 2012, AIR 2012. I don't remember the page. But the opening paragraph, I acknowledge that one of the problems was because there was a lot of ideas floating around, some 2-page ideas, some 4-page ideas, without anyone really reasoning out the entire process as to why it should be. And in course of the discussion, I had to deal with what Bhatia actually meant, what Venture Global actually meant, and I don't want to correct Mr. Nair, but there are one or two things, Bhatia and Venture Global have to be understood in that perspective. Bhatia never said that a foreign award could be attacked in India. What Bhatia said was, in respect of an international commercial arbitration, which by definition is that the seat is not in India, Part 1 of the 1996 Act would apply for interim protection to be granted in aid of the final release claimed in the arbitral reference. That is exactly what Bhatia said, no more. Venture Global again has to be understood. Venture Global by no stretch of imagination said that Section 34 of the Indian Act, which is the annulment proceedings, as setting aside applications are called internationally, could be extended to a foreign award. What Venture Global said was, the entirety of the 1996 Act does not probably preclude a suit being entertained against a foreign award or an international commercial arbitration. So that was Venture Global, because if Venture Global had directly said Section 34 would apply, it would be contrary to statute. Now, Venture Global was ultimately found to be bad law and overruled in Kaiser and Balco. Unfortunately, so was Bhatia. And that's where I have something to add as a student and in an academic discussion, that's where I think jurisprudentially we have gone wrong. And I have absolutely no doubt that in course of time we are going to get back Bhatia, because Bhatia was a futuristic, forward-looking judgment. The difficulty that Kaiser felt with Bhatia was that if Part 1 of the 1996 Act was opened up, then all Indian courts would use that judgment as an excuse to apply it in relation to a foreign arbitral award. But imagine a situation where A in country X enters into an agreement with B in country Y, where X and Y are New York Convention countries. Now, the idea of the New York Convention, and you've got to understand the basics, fundamental to the convention, is that the award made in favor of a party in a New York Convention country will be respected by other New York Convention countries. That's the fundamental basis of the convention. Now, if it is the purpose of the convention to uphold a convention award, then what is the use of a party going and getting a convention award if by the time that the award comes, the subject matter of the award is wasted? There are cases in which unless interim measures are granted, there will be no recourse to implementing the ultimate award. And Bhatia was jurisprudentially forward-looking in the sense that it anticipated this, and it was in furtherance of the New York Convention. Unfortunately, it did not get appropriately appreciated in the Constitution bench judgment rendered by a solitary judge of the Supreme Court. There's no supporting judgment of anybody else. Now, I'll give you an example as to what I'm talking about. I think you would have heard of the freezing orders that were passed in England against the Papa Doc and Baby Doc regimes. Haiti had a succession of repressive regimes headed by a president called Jean-Claude Duvalier, and later it was as if by inheritance the presidency went on to his son. Jean-Claude was popularly known as Papa Doc, and the son who later inherited the repressive regime was known as Baby Doc. And between the two of them, they had an army of rowdies who looted all around the country, and that army was known as the Tam Tam Makut. Now, once the Haitians ultimately rose and Papa Doc had died and Baby Doc was driven away and the Tam Tam Makut was running for cover, they had their money stashed all over the world. And so you had applications for freezing orders in England, and the English courts, through a long drawn process, not maybe as long drawn as in India, but over a period of time rendered orders where they thought that they had the territorial jurisdiction to pass freezing orders restraining any action being taken on the instructions of anyone in England or through organs in England by which this kind of money transferred and was parked elsewhere. In a post-Bhatia overruling in India or in other countries, it will be difficult to have interim orders which are really for the purpose of preserving the rights so that the ultimate New York Convention Award can be implemented. So that's on the jurisprudential part of it. Now, as a commercial lawyer, and I was an out-and-out commercial lawyer, primarily practicing corporate law, and I always thought that these judges don't understand much of commercial law, they don't have any time for these things, and I always thought that commercial bodies were hard dealt by the Indian judiciary. I'll give you some examples. For instance, there is a practice in the lower courts in India that if you do an immovable property, you will get a status quo order. That is generally the rule. So one of my foreign clients, a Japanese company which was one of the downstream projects in after the Haldia petrochemicals, suffered such an order, which meant that a part of the land on which the factory was to come up couldn't be touched, and it was a pocket right in the middle so that you couldn't do anything around it. It wasn't at the edges that you could ignore it and temporarily construct, and it was frustrating both for the Japanese clients and me because we couldn't get the court to hear it because the court did not consider the matter urgent enough to take it up out of turn. And I thought it was the Japanese party had been hard done by. But as I got onto the bench and I saw the priorities that a judge has to weigh with, I don't blame the judge as much as I used to do then, because maybe this was a loss of face to the country, maybe this was causing immense loss to an investor, but there are other many important matters pertaining to small rights of small people which require more immediate attention than bigger commercial matters like this. So we must keep that in mind when we are talking of the judiciary and the resources that the judiciary has. I was talking to some of you prior to this conference, and I was saying that, we don't have enough time to think at times. We don't get matters which make us think, or we don't get the luxury of thinking because we are always tackling numbers rather than tackling lives which we are actually doing. So I apologize, as I was telling some of you earlier, I apologize to one of the lawyers 3 days back because he had just finished 2.5 sentences and I was into this habit and I was dictating. And when I finished it, I looked up and he looked perplexed. I apologized to him and I said, sorry, but your third sentence would have been this, your fourth this and your fifth this. He agreed. I said, very well, in this case I'm right, but I realized that in 10 other cases I could be wrong. That's because of the pressure of numbers that we have and not enough resources, that we are sometimes treating matters on the basis of certain symptoms. If, like the example that I gave, that if you came and said that I have fever and I have a little bit of an ache over here, I just don't hear you anymore. Mom, very well, take this. Next. But, we've got to give ourselves time to think. Now, in many areas, these matters almost result in some kind of an ego battle between courts. I can give you one example, as in Shashua and Sharma, between the English courts and the Delhi High Court, there was almost an ego hassle, right? I remember an incident that happened in Calcutta about 15-20 years back. We had an India versus Pakistan friendly hockey match, if anyone remembers. And as you know, hockey matches have referees on one half, referees on either half. So suddenly the Pakistani referee thought that the Indian referee was favoring the Indian team, and we had a farce that anytime the ball came into the half where the Pakistani referee was refereeing, everything went against India, and when it went to the other half where the Indian referee was refereeing, everything went against India. Now, sometimes in cases like this, particularly in anti-suit injunctions or anti-suit injunctions, there is a kind of an ego hassle or an ego battle between courts of different jurisdictions. Now, there is one problem that I see in all this ultimately happening and India being bound by investment tribunal awards and India's exposure to such kind of agreements. There is a constitutional problem with it, because if the award is because of any order passed by the Supreme Court, then to what extent even the executive has the authority to account for it or maybe suffer for it is something which the Supreme Court ultimately has to take up and test. I don't think that in the Indian constitutional context, the Indian government has even the authority to enter into an agreement that binds the Indian government to compensate anyone for any order passed by the Supreme Court. It may be wrong, but I think in the Indian constitutional context, that's an issue that's going to come up. The other thing that I just in my judgment, I've referred to judgments from various jurisdictions, and you'd see how in many countries, Argentina, Philippines, Indonesia being the few that I remember, how courts have come to the aid of a party despite it being pretty obvious that the parties of that country were in the wrong. Unfortunately, in India, such motives have not been attributed to Indian courts, though some Indian judges are sympathetic to public sector undertakings in India, and Coal India Limited, as you know, is a public sector undertaking. So those are personal kind of prejudices of judges. Even to me, I'd be very happy to take them, but this idea of investment arbitration and of expropriation, particularly judicial expropriation, I think needs a relook, particularly in the Indian context and in our constitutional scheme of things.
issues that you've raised are extremely important, especially the constitutional issue, which is inevitably going to come up at some point in time. And anybody has any questions to any of the panelists, please feel free to ask.
On this or related matters?
On any issue.
Now, rather than, it's not also a question as some point I want to put before the panelists here. Now, Justice Banerjee mentioned that how he thought that Bhatia should not have been overruled in Balco Kaiser for certain reasons, right? And part of the reasons is because it allows interim orders to be passed in context of foreign arbitration and international arbitrations, even by Indian courts when the seat is not in India. Now, as a matter of fact, if you see the Amsterdam model on which our act is supposedly based, it in fact creates this possibility by saying that 4 provisions of Part 1 that is there in an act, 4 provisions, including Section 9 or Article 9 in the Amsterdam model, should be applicable to national commercial arbitrations outside the country as well. Specifically for the problem that Justice Banerjee highlighted. That is because that in certain like for example now, if an arbitration is taking place between an Indian entity and an English entity in Switzerland, then it will be passed by an arbitral tribunal, then enforced in India as a foreign arbitral award or an interim order or something of that sort. And that entire process would take so long that those assets may have been wasted. Now, is it sufficient as of now, and as a practitioner, specifically Mr. Nair, whether, is that a problem that exists now? Because for practitioners, post-Kaiser, how would you deal with this problem of having an interim order in such a manner?
On to that question, I must disclose a conflict of interest. You said as an arbitrator, the first thing that you're supposed to do before you actually put pen to paper is to disclose a conflict of interest, because what you don't want to do is to have future proceedings tainted. A counsel who appeared in the Balco case was instructed by NLSIAM2 India, and we took a very clear position saying that Balco, Venture Global and all its progeny were wrongly decided. The Supreme Court has accepted those contentions, and I'm quite a happy man. I of course see the problem which Justice Banerjee flagged up, and the problem which you raised is what do you do if you really need interim measures in support of an arbitration when the seat of arbitration is outside India, but the actual assets against which you might have to enforce the award are situated exclusively in India. The ways, well, of course, the issue is really one of legislative intention. The point is simply that India, when it decided to enact the UNCITRAL legislative template into Indian law, did not follow that approach of making a carve-out and saying that despite the fact that the normal rule is that the seat of the arbitration determines the jurisdiction of the courts, it did not deem it appropriate to carve out exceptions. If you look at the UNCITRAL model law, the exceptions made there. If you look at the English Arbitration Act, the English Arbitration Act very specifically states that even where the seat of arbitration is outside India, is outside England, the English courts will nevertheless have the power to order interim measures. So the cases which Justice Banerjee referred to are essentially supported by an express provision in the English Arbitration Act which confers jurisdiction on the courts. In the post-Balco world, I think what would be necessary is for arbitration clauses to be drafted more carefully and for seats of arbitration to be chosen more carefully. If you anticipate that you will need recourse to a court to seek into the measures of protection, and if you think that it's more likely than not that you'd have to approach the Indian courts, then the drafting remedy that you have is to seek your arbitration in India. The second option is you could have probably a floating arbitration clause, in the sense that you could have a default seat but give an option to one of the parties to change that seat to India. So at the time when a dispute arises and you think that you probably need the assistance of the Indian courts, you can reserve the power to yourself in the contract to move that seat to India. But don't forget that approaching a court is the only option to obtain interim relief. What you also have is the ability to seek interim measures before an arbitral tribunal. You also have the ability to seek interim measures before the courts at the seat of the arbitration. So if you have a situation where the seat of arbitration is, say, Singapore, and you need interim relief, don't think that the only place where you can get interim relief would be the Indian courts. You can obtain interim measures before the arbitral tribunal, you can obtain interim measures before the Singaporean courts, and to be honest, in the vast majority of cases, interim measures that are ordered by a tribunal are usually complied with. You will probably need a rogue defendant in an arbitration to actually say that, well, despite whatever the arbitral tribunal decides or what the courts at the seat of the arbitration decide, I'm not going to comply with it.
If I may add a point here, Energy said, and the problem which Bhatia, overruling of Bhatia poses is something very true, because in fact the Singapore example which he was giving, in fact Singapore went the other way. First it had refused that we will not interfere in a Section 9 kind of a situation where seat is in North Singapore, while they then make a legislative change to say specifically that even if the seat is outside Singapore, we will allow a Section 9 petition to come in Singapore. Singapore being Singapore, they could bring that legislative change much faster than what we expect in India, but actually Singapore has addressed exactly what Justice Banerjee pointed out. And so far as the enforcement is concerned, other than what Pramod mentioned, and again taking the same example of Singapore, under the Singapore International Arbitration Act, such interim orders can also translate into a judgment of Singapore courts. So what it means is that one, it can easily be turned into a judgment of a Singapore court in a day, and two, you can enforce it as a judgment so far as India is concerned, and three, it can even amount to a contempt of court if a person is not following it. So I think there are obviously some respites or some remedies, but nothing like what Bhatia gave to a foreign seated arbitration.
I have the same conflict of interest as Pramod, because I was representing Nani Palkiwala Arbitration Center there, but I subscribe to the in-between view. Bhatia said Part 1 applies unless expressly or impliedly excluded. Valco says Part 1 can never apply if the seat is abroad. My view is that Part 1 will not apply unless expressly or impliedly included. That is my view. And the reason for this is, look at the opening words of section 28 of Part 1. It says, if the place of arbitration is in India, and then it starts with the rest of it. So this contemplates a situation where Part 1 would apply even where the place of arbitration is outside India. If Part 1 would in any way apply only if the place of arbitration is in India, then there is no need for section 28 to open with the word saying if the place of arbitration is in India, these provisions will apply. It clearly shows that there are certain situations in which Part 1 would apply even where the place of arbitration is in India. In such a situation, section 28 would not apply. Therefore, in my view, it is definitely permissible for parties to expressly include Part 1, even if the seat of arbitration is outside. Coming to implied inclusion, if you are going to construe an implied inclusion based on the principles of private international law, then that would automatically mean that if the seat of arbitration is outside India, then it is deemed that the law governing the arbitration agreement follows the seat, and therefore Part 1 would stand excluded. Therefore, that's my viewpoint on this.
Yeah, lawyers have been enterprising enough to approach this with suits exclusively for interim measures. There was something before me which was about to be decided before finally I persuaded the parties to accept some kind of solution. Unfortunately, they accepted that. I lost a chance to express an opinion on that. The second aspect is that you must understand the position with the help of an example that is in one of the textbooks. It says that if a lady from England goes to France and finds all the traffic coming to the left, by also driving on the right, she does not submit to French traffic law. There's an easier way of looking at it. It's for her to realize that she is in France. You know, that is the entire approach of this concept of territoriality. I also have a serious difference with Kaiser Balco in its interpretation of Section 2, not only 28, in its interpretation of Section 2. I don't think the entirety of Part 1 can be excluded to foreign arbitrations in the absolute kind of manner that Bhatia has sweepingly said. So, Balco has sweepingly said. There are many areas in Balco which need to be ultimately corrected.
Should be applicable 4 provisions from Part 1 which are nevertheless applicable to international arbitrations. I pointed out earlier, I think Mr. Nair also alluded to. Those 4 provisions. And that is why those lines are there in Amsterdam model saying, except where the place of arbitration is in that country, then Section 28 blah blah blah. So that's a problem because we just took that thing without looking at it. Whereas we didn't include the exceptions. So I'm not sure whether that shows, the Section 28 shows legislative intent otherwise. Rather, they've copied one part blindly and forgotten to take the exception that both Ms. Narayana alluded to earlier. Now, the other point what I was trying to get at was the efficacy. I mean, I can understand that not too many claimants before an arbitration will want to be rogue, as you pointed out. I mean, I can understand that they would want to follow whatever the arbitral tribunal or the courts of the seat say, especially in interim measures. But there have been instances where this has happened, and that's exactly the problem that this creates. I mean, that's the problem we're dealing with here. How to deal with that problem? That's the question before us. So what I'm trying to ask you, I mean, as a panelist, as practitioner especially, how do you go about dealing with the rogue investor, the rogue party before the arbitral tribunal? Or how do you rather now enforce an interim award passed by either the arbitral tribunal or a foreign court in India now? I can understand one method, as Sir pointed out, was through by taking it as a judgment of a foreign court. But again, that has a lengthy proceeding in India where you have to file under the Civil Procedure Code and then try to implement it, right? So is that model efficacious? At least for, still, does it protect the party before arbitration anyways?
This is actually becoming a session on the correctness or otherwise of Balco and Bhatia rather than investment treaty arbitration. But I think it's important to understand how domestic decisions like Bhatia and Venture Global can actually engage international responsibility as well. It's certainly an important point. The first point that I'd like to make is I don't subscribe to the view that you might actually be able to get a judgment from the Singapore court granting you interim measures and that you could easily enforce that judgment here in India. And the reason I say that is because what is actually enforceable in an Indian context is a decree. And you don't get a decree in respect of an interim measure. And even in respect of a decree, what you can actually enforce are the money decree can be enforced, it's not anything else. So you really can't enforce an omnibus judgment giving an injunction. An injunction by a foreign court, irrespective of where that court is not something that can actually be enforced in India under the CPC. The second thing is, I think there are limitations, and I think it is very difficult. I'm sure Mr. Justice Banerjee will not mistake me when I say this, but it's very difficult to tell an Indian judge that you actually don't have the power to do something.
No, I completely endorse that. I completely endorse that because as a lawyer, the first thing that you say that your lordship can do everything, but you know that the catch is in the butt. But if I'm not interrupting him. One of the major problems is because, as you would see from Venture Global particularly, if I were a judge only on facts, I would say that's right. But if I were a judge on principles, that's utterly wrong. And sometimes in India, I would even take a step forward and say because of the kind of quality that we have at every level, we do not judge on principles as judges should. So that results in a lot of complications.
So the point that I was trying to make is that it's not as though you always have a legal or a judicial solution to a dilemma. This is a dilemma, this is a problem, but I think the proper forum to address that problem is the parliament and not the courts. And the fact is, this was actually the kind of amendment that was proposed in 2001 when the Law Commission came out with its report recommending amendments to the Arbitration Act. This was also the proposal made by the Law Ministry's consultation paper on amendments to the Arbitration Act. Both of them were unanimous that the parliamentary intention at the time it enacted the 1996 Arbitration Act was that the Indian courts would not have the power to intervene either in a Section 9 or a Section 34 context when the seat of arbitration is outside India. But what both these proposals for amendment did was to carve out exceptions, and carve out an exception in respect of Section 27, and carve out an exception in respect of Section 9. So that would actually enable the Indian courts to, one, order interim measures in support of an arbitration even when the seat is outside India, and secondly, also assist the parties with obtaining evidence irrespective of the fact that the seat of arbitration is outside India. So these are proposals that unfortunately have really gathered dust and have actually not been robustly pursued before the parliament, but I think that's the proper forum and not the courts.
Yes, I agree that part of the answer to our model law has been copied and pasted, the rest of it has not. But today when you have a statute, it is a fundamental principle of interpretation that you need to give meaning to every word used in the statute. And in my view, if you give it the interpretation that I suggested, parties would have an option of having a seat outside and expressly including Section 9. That could solve the problem that we are now discussing. If they then decide not, then right, that's their decision. You give respect to party autonomy and leave it at that.
I have two questions. I think both are sort of connected in some way. I think we've spoken a lot about legitimate expectations. Now let's take the example of India today. When an investor is probably walking in, economic considerations as well as he considers the investment climate. My question is that when an investor walks in, he's aware that the judiciary is overburdened and you're not going to probably be able to enforce your rights at a pace that you would in a sort of a developed legal environment. Number one. Number two, you have in a developing economy a fluid regulatory environment. Now let's take the case of Vodafone. Now in a Vodafone sort of situation, you have a lot of aggressive tax planning today that's happening from foreign investors, and there are bound to be clarification, there are bound to be retrospective amendments. And let's take the example of a general anti-avoidance rules that the government seeks to introduce. If the government does introduce, you will have situations where the department will change the commercial nature of the investment. In such situations, what is the exposure that the Indian government faces, and would that actually be, in case there is a retrospective amendment such as the one in the Vodafone case, would that be a breach of the legitimate expectations of the investor? And also, how would this play out if tomorrow Vodafone were to challenge this judgment in the Supreme Court, and Supreme Court were to say that, look, the retrospective amendment is constitutional, how would you take this to a tribunal? How would you portray this to the tribunal, whereas the highest court of the land has clearly held that the act of the state is completely justified, and you go to a tribunal and say that this is wrong, number one. Number two, and I think this is connected, in light of what we have seen, do you see that, in the entire regime of bilateral investment treaties, there is time now for developing economies to reconsider the kind of agreements they are entering into, to ensure that they protect their interests insofar as regulatory changes are concerned, because there is some commonality now we see, and developing economies cannot have the same, they cannot be held to the same standards as probably developed economies, and this regime is already in consonance with international principles, because you see something like that in the case of environment laws, where you have different standards for developed and developing economies. So how do you address these two issues?
Additional part of that, and then the other aspect. If there is a law within the country, and if that is constitutional, that's one aspect of the matter. As to whether that law is in consonance with the state's obligation in a treaty or in a bilateral arrangement is a completely different kettle of fish. So that would be my judicial approach to this. But the other aspects, of course, I think some others should.
Questions that you raised are very important. Firstly, let us try to understand in this way. Our government has sort of made life complicated for itself unnecessarily, and with all due respect to the parliament, which sort of brought it the retrospective legislation and all. It's a very interesting thing that I would like to share with you. As part of my doctoral research, when I went on doing my field trip, field research, and I met officials from Finance Ministry and Commerce Ministry who deal with bilateral investment treaties, I was amazed to see that there are officials who deal with bilateral investment treaties and they don't even know what is the actual meaning of these treaties. So when the question was put to them that do you take these treaties into account when you adopt regulatory measures? In other words, when the Environment Ministry decides that we are going to sort of say a no to this particular project, does the Environment Ministry look at BIT and sort of then decide its regulatory cost? The answer is no. And the reason for this is very simple. There is very, very little capacity within the government, and I don't know if I may say that, within the judiciary also, to understand the implications of something like bilateral investment treaties. It is for this reason that we have been signing treaties since 1994. We didn't care about these treaties till 2010. And I can bet this and say that had these arbitration notices not come up, we would have still not cared for these investment treaties. So we are actually waiting for foreign corporations to tell us that we need to look at these investment treaties more seriously. We never learned from the experiences of other developing countries. I have written articles saying that India should learn from the experience of other developing countries who have undergone through the same experience. But then the attitude in the bureaucracy is that we'll see when the actual problem comes, and we don't need to deal with the problem till the actual problem comes. So that is precisely the attitude, the problem that we have. Immediately after the 2G judgment, you had many foreign corporations issuing notices under the BIT. On the other question of developing countries being careful on the language of the BIT, let me say that this is not just a question for developing countries. If you look at the empirical evidence all over, it is first the developed countries who reacted to these arbitral awards. It was US and Canada who were worried with NAFTA arbitral awards, and they said we need to clarify what is the meaning of fair and equitable treatment. US and Canada have adopted 2 or 3 new model BITs, and then the developing countries have started to sort of look at this issue more carefully. So this need not be looked only from the perspective of developing country. There's an issue which every country which sort of wants to preserve its regulatory space has to take this into account. I'm also sort of very difficult for me to resist the temptation on commenting on what Pramod said and what was said also about the role of whether the judiciary's content can be challenged under BITs. I don't know whether all of you are aware of this or not, but the Attorney General had a point, this sort of was reported in the media very widely, that in the view of the Attorney General, the BIT claims can't be brought against India for the actions of the judiciary. And the argument was that you can't bring claims against the government for what the judiciary has done. The Commerce Ministry and the Finance Ministry opposed this particular view, and they asked the Attorney General to reconsider the opinion. In December, again, it was widely reported in the media. We unfortunately don't get to see those advices, but it was reported in the media. The Attorney General has reiterated his earlier stand that yes, you can't hold the government accountable for the actions of the judiciary. Now, as Pramod rightly mentioned, there's a very fundamental flaw in this reasoning. International treaties don't bind the government, international treaties bind the state. The executive signs the treaty on behalf of the Indian state, and this is something which is very, very simple and given in international law, and this should not, in my view, create unnecessary complications. I completely agree that you may have a law which is constitutional, the Indian judges have to apply the Indian law, but you also have to look at whether this law is in consonance with your international obligations. If this law is not in consonance with your international obligations, you will be in breach of your international legal obligations internationally. You may not be in breach of your domestic law, but you are very much in breach of your international legal obligations internationally. Now, this distinction has to be very, very clear in our minds, and we sort of cannot confuse between these two parts. Thank you.
To us for having this excellent discussion. Thank you to all the other panelists as well who made sure that this 2.5-hour session was extremely productive.
International Law School and the Moot Court Society and the Indian Journal of International Economic Law. I'd like to thank the panelists for that wonderful debate. If anyone has more questions, they can perhaps address the panel later. We will now begin the finals in the next half an hour to 45 minutes. I hope you stay for that. Thank you so much.